Your Lordship Director, I have filed an affidavit in item 15 that is for
Maybe I beg to mention item number 30, 31,
item
item 30, 31, 30. Only for that.
petitioner after
But item number 24, the product case was again adopted by
the petitioner. Sorry. May it please the Lord, the concern of the other side matter. Item number 10, footprint. Item number 10 matter. We like to the records were called for, however, the records have not been available today. The concern of the other side, my lord, may matter be fixed on March 20. Item 10. Yes, my lord. Item 10. Yes. When? What is the urgency to fix the date? My lord, the urgency was on the opposite side. Done it at 100%. But the records were not. What is the issue? The issue is regard to they are asking for a benefit, whole pension benefit. Okay. One group you have given, you want that state approval that which is that. Yes, after. My lord, 24th. My lord, that would be 21st. 21st.
7.
Divided 3%. 7th of March. So many methods. 19. 19th of.
Wait, please. Hello, I beg to mention item number 26.
Yes.
Senior plus personal submit our subject. Adjournment note.
What are these methods 2015?
But
As
if
Sahaya. 2015 method. You have for respondent or
respondent,
respondent with respondent.
I for 26.
25,
26.
26.
Yesterday we have submitted.
2015 method is critical.
Plus. In this case, for petitioner is on interim, is there is
Not when
my lord on 17th of March.
19th of
9.
Okay.
Why this method is listed here? Yes, 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 1 minute. Earlier rejected by
Yes,
me.
I had accepted by your. No, my lord, probably. Sorry, your lordship.
Huh?
This case was not rejected earlier regarding accused number 1, your lordship has rejected. Probably with view of this court, yes,
So the case one is the compliance code and the second is the repetition of the letter to take it off. Not be considered given a 3 week time. 30% instead of 12% rate of it. Run it output respondent. Yes.
What the file? On the last occasion, I don't have the brief. I have one judgment to show my lord and as well as the fixing order. He is otherwise not my lord, and that's important. He has no qualification in it. I will take on the part.
Okay. Where is the where is the order?
Yes. May I place the advertisement first?
Contempt in which case? Where is the order? Let us look at the contempt in first. Where is the
Yes. Next. Part. Part.
oh this is the case. Yes. File affidavit.
Well, only one thing, my lord. My lord, to my lord submission, my lord, that is not necessary. Apparently, page 22 of the decree. Yes. Admittedly, the petitioner applied for the post of medical record officer. Serial number page 20.
22.
Yes.
Okay.
My lord, will see the minimum qualification: graduate in arts, science, commerce from a recognized board.
Serial number
6.
Medical record officer. Which was the advertisement?
Yes. Graduate in arts, science, commerce from a recognized board or university with medical record.
Officer training.
Officer training from recognized. So
Okay.
additionally, this training is required.
Where is his qualification?
My lord, if we can show this, my lord, that he has this particular qualification, well, I have then in that case he will be added, or we'll have to find out. Let him show, my lord, that he has this one. And my lord, one more thing I'd like to point out. What we will see at page 23. This is the type copy of the admit card. I would like to point out page 24.
Page 20.
24.
Four.
Note before 1. NB1. Candidate who does not have the minimum educational qualification and whose age is not within the prescribed limit as mentioned in the advertisement dated 27/10/2010 need not appear in the examination. The candidature of the candidate who appears in the examination shall be rejected at any point of time after detection of his or her inability.
What was the earlier direction?
Direction was, my lord, to consider what you will find that 44 or say 43 months, page 43 of the judgment.
No, this is review. I think 34. 34.
34 months. 34 page 35. In view of the aforesaid consensus arrived at in the part, this petition is disposed of by the principal superintendent and the director of medical education to duly consider the case of the petitioner for appointment as medical record officer in Fakhruddin Ali Ahmed Medical College and Hospital, Kolkata, in terms of the recruitment exercise initiated by the advertisement.
Now, why review?
My lord,
Why review then?
at that time, my lord, probably the CME advised that, my lord, place this particular fact with him later on, that, my lord, he is otherwise not qualified. This was brought into it. The honorable could say that now contempt has been filed. You either consider or face the contempt. In that, thereafter, my lord, this speaking order has been passed, wherein it has been clarified that he doesn't have the qualification. Now, this is the main, my lord, criteria prescribed for this particular post. And without having that kind of particular requisite qualification, I don't think so much he has got any right at least to stand before after this fix. More particularly, my lord, there is nothing to show in the petition that he has this particular.
Okay, then
Then Lordship may kindly have a look at page 30. This is a reply to the RTI minor subject to the petition. There we have stated reply to question number 2. Page 30. Appointment process is not yet executed, so appointment of the candidate against the state court does not arise. Higher authority is looking after the matter. Thereafter, the speaking order, page 45. Page 45, annexure 11.
yes,
Only one minor final judgment, reported in minor 1989 1 para 12.
That is on the training. Yeah, I accept it. So it is it method that statement at that time nobody have available this training. These facts are well emphasized by the respondent and accepted all the applications of the candidate. My application accepted, then test conducted. I have passed. Thereafter, they issued a notice for document verification. Page number page number 26, document verification done. Thereafter, one order, another order been passed. Page number 28. Page number 28. Last paragraph.
Hmm.
Thereafter, start the block, long day. I have filed RTI application page number 32.
Hmm.
They have replied question number 1. Answer question number 1. Post of the medical record of is kept and high of mark issued by the candidate. Earlier I had filed the repetition only challenging this ground. In that repetition, the respondent appeared at the file PDP. He had no objection as he has joined in another. Considering all the facts and submission by the respondent, this honorable court asked the order to consider my case. In that repetition, the respondent appeared and in the order clearly reflected that the DP Bora, the Land Standing Council, has also fairly submitted that in view of such categorical stance of the respondent number 5, the department may be dedicated to consider the case of the petitioner. There are only grounds due to tie of mark the post step second. The training code is after at that time was not available anybody, and after attachment the this training has been published by the central government. This after advertisement, it also in service training. Thereafter, they filed a review petition challenging this order. Only ground that I have not qualified. which is dismissed. Thereafter, they preferred appeal, writ appeal, which is dismissed, push pause. Thereafter, they preferred appeal. In the appeal,
Where is the appellate judge?
appeal,
Do you deny that there is a prescription of a specific qualification in the advertisement?
I have not denied.
Did you challenge that criteria? That see, this is not available. No.
I have
What
not.
was the direction it to say that you consider it? Now they sought a review. Review also court said that will not enter into this aspect whether available or not available because direction was only for the consider. So therefore court says there is no ground for review and let them comply with the earlier order. Now they have decided that nobody was having qualification. So we are not going to that. Is there any right of a selected candidate to be appointed more particularly when admittedly you are not having the qualification?
Their qualification was in service qualification. Start getting appointment, they would give opportunity.
Where from are you saying? But you have not challenged the advertisement itself. You have participated without having the selection. Now they have decided, okay, we will not go for with this selection. We want a qualified. But can we now issue a writ of mandamus to appoint him?
They have not rejected my candidature at the earlier stage. They have
What
conduct.
is your right to be even after selection? Even after you are having a qualification, you are selected? Can you issue a writ of mandamus to appoint him?
I thought this case.
Huh?
They have emphasized all this step that nobody has this qualification.
Hmm.
And considering this step, accepted all the application of the candidate and candidate conducted
Now they have decided that
women
we
verification
require this
conducted
qualification. This is essential for record keeping. We will not go for a press release.
in the review petition. The judgment clearly mentioned that the state qualification is not correct.
Come to the review judgment.
Page number 43,
Page number, come to the review judgment.
review the
Court says the learned counsel for eligibility appears to be correct in contending that issue of eligibility vis-a-vis the requirement of having medical record written cannot be raised as it was not possible at all for any candidate to fulfill the state condition as same was introduced even less than a year before the advertisement. Now come, however, the direction of the court being only to duly consider the case of the petitioner for appointment as medical record officer, this court would refrain from making any further observation on the said issue.
their down, that type their down only
No, you will go to that. You first satisfy us that you have a right to be appointed without that qualification. Number one. Number two, that a writ of mandamus can be issued to by directing them to make an appointment. We will issue a writ if you can satisfy.
if
Hmm.
the initiate stage they gave 10. If I have not challenged it, at that time my case was
Suppose that was also correct. They initially thought that this is a time up, so we'll think of our path. And subsequently they decided no, we'll not go. Nobody is having any qualification.
I am,
What is the wrong and your legal right that has been violated? Say us, we'll right now we'll issue a merit of mandamus.
I am ready to operate this training, but getting appointment. Yes, this qualification is like in service qualification.
Where from are you saying all this?
Yes, I have enclosed the advantage
In terms of the service rule, what is the essential quality for a person?
is only training.
I'm asking you, for a post,
Yes.
there are certain prescriptions in the rule or maybe executive. That for this post, this is the qualification required. Do you propose to say that there is, if you want to say that this is the qualification, this is not an essential qualification. Therefore, they cannot reject my candidature on this ground.
That qualification are essential except training.
From where are you saying?
Yes, training is in service. Before obtaining
Oh, from where are you saying?
logic page number 46, Government of India introduced the code on 26 September 2016. Subject in service training course of medical doctors.
What is the essential qualification for this post?
Graduate in art, science, commerce.
No, I'm not saying from the advertisement. See, if you want to argue a case, you should come prepared. If it is your case that these are not essential qualifications, therefore I am a selected candidate only on this ground, they cannot reject. And every state action must be a reasoned order. And this reason is violative of my right under Article 16 because this is not even a prescription. How can they insist on that? You are saying that it was not there. Where do you get this? These are the training courses for in-house persons. Those who are already there, those who are not having, these are the essential. Can be training can be granted. So Union of India has intimated everybody. These are the institutions we can give training for in-house candidates. Will it mean that this is only a in-house? No. Then yes, Gogoi, what is the prescription?
Here's the next one document of the central government.
No, that 46
For-
is basically
Yes. Persons who are already
46 is
there,
basically
they can have a
who are there now. Union of India says that in terms of this, these are the courses institutions offering the 6 months courses for already employed candidates. So you
Yes,
can send
can-
them to these institutions.
they will
Nothing
get
more,
second.
nothing less.
Yes.
But what is the prescription of essential qualification for this?
That melody is apparent from this melody, page 48. But you will see otherwise. Graduate melody 1.2.
No, these are in-service
So
training.
even melody for having the training,
Hmm.
even melody for an in-service candidate, we will have to be a graduate.
He's a
So
graduate.
he is a graduate
Ah.
and we want this particular training.
No, we understand. But what we wanted to know is that what is the essential qualification as per your service rule or
Service to this particular post is not yet. These are new things that are coming up and it is quite medical colleges. Here, Lordship has already has fallen out for the honorable post. If at all he has a case, we'll have to challenge this particular advertisement on this particular post that this is fair. This particular criteria cannot be fulfilled for this reason.
it's an impossible
He
condition.
participated. Now he wants that it should be directed.
Impossible condition
Yes, that he has not
that
done.
he has not done.
Even in the second lead petition, he has not done. That ought to have been the ground.
And the review, there is no specific observation. Court says will not go into this
Yes.
matter because it's only a consideration.
Consider it.
Don't repeat whatever you have said for last 50. if you have any substantive thing to argue. We don't have scarcity of time, but don't repeat what we have already said. That we have already recorded it.
So they give up time.
So what I think definitely only
See,
okay.
come prepared. You are taking responsibility of a citizen who has come to the being agreed. Whether he is having a right or not will decide. You have a responsibility. Come prepared.
So there will have to be specific relief have to be followed in
The learner after sharing some lack, the learner enough. It's for an environment properly prepare and answer. They are the help is better.
that. Obliged.
What happened? That has been satisfied. According to you, they have sanctioned your pension. Last year, what have we made the submission we have recorded?
That is
Huh?
better is the what with
Okay, we'll call a little bit later. Yes. Okay, we'll learn it.
knowledge.
Hello, if your lottery takes up the affidavit, I want to read out para 3. In fact, Corpusary, where is Corpusary? Corpusary name not para 3, Malo. All Corpusary. In compliance with the lottery order, all Corpusary are relief. Affidavit. Yes. Malo, in fact, in compliance of the lottery affidavit, Malo, I that file yesterday. Which is Vinod Kumar Agarwal. Yes. And what is this? Not this same affidavit, I think. Okay, which paragraph? Paragraph 3, my lord. By the state order means your lordship order, the Honorable Court directed the respondent department to place on record then in respect of the banking question. The deponent submits that the government, the highest level, the corporation department has taken a call in the matter and proposes to finally resolve the impasse existing in the bank by taking a concrete action without any further delay. The deponent further craves leave of the Honorable Court to make a prayer for granting at least 10 days time to put on record the final decision of the government in the corporation department on its matter. But what has happened, I am told, my lord, but will not put on record that the principal secretary, my lord, has taken up the matter at the honorable. So within 5 or 9, within 10 days or 2 weeks, my lord, everything will come out. What the government is proposing. So that it can be a reasonable time. I'll place on record. Okay. 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 Yes. But that I think that why is and that court has not been placed. But perhaps also be important. Let us. I think if the Honorable Chief Minister is considering the matter, definitely they will have consider also the inquiry report. So immediately at this stage, we propose that we should pass certain directions because they is under consideration. So that has been stated in an affidavit. Let us wait for some time. I think it will be in everybody's benefit. And it may go either way. If the government decides to go for liquidation, that type of consequences follow. Our concern is that it is up to the government. We cannot delay to do a certain policy. But your lordship wanted to expedite the matter. Expedite, and at the same time, we want our orders to be implemented. The orders to be implemented, and whatever way you do it. Correct. But will not
When
Whenever sometimes it's positive response are coming. Correct. Pursuant to the earlier order of this court passed on 21/12/2022 and it's 15 to 2024. The the chief executive director of Escort Bank has filed an affidavit and a specific stand has been taken that the highest the government in the highest level, the co-person department, has taken a call as per call in the matter and proposes to finally resolve the impasses existing in the bank by taking a concrete decision without any further. However, it is further it is the it is the further that such process may require at least 10 days time. 10 days time. Accordingly, the taluk got for no, for some reasonable reason that because it may not crystallize within 10 days. No, therefore we are adjourning for 2 weeks. Yes, instead of saying 10, not 10. Reasonable time. According as a positive approach has been taken by the respondent state as well as Escort Bank in the interest of justice and in the interest of the petition in the considered opinion of the state authorities in the state will be granted a reasonable right of it. Accordingly, the accordingly the matters that adjourned and be listed on after week 21st of March 2024 by the next date representative the pride report the update. Yes, yes, Mr. Hello. You share it. Yes. List this method in the orders column. On 21st.
as was directed by your optimal, I have gone through the new CRPC which will be implemented from 1st of July. It's for Bharatiya Nagorik Suraksha Policy. And there are perimeter provisions. New CRPC incorporates the word unit. In respect of 451,
Now, why should we do a serious exercise before July?
in fact, precisely, my lord, there are orders.
Go to the respective trial court.
That will cover. This is the order of a coordinate bench, my lord. By this matter, several persons have gone to trial and they have in fact got the custody also. Yes.
This may lengthen since it's already been resolved by the legislature.
Yes.
Huh?
From 1st of
Parliament
July,
has-
my 1st of July, 451 as well as for a division bench order will have no impact.
So to them.
Yes, but they have already discussed. It is quite
So in all these cases, dispose of.
yes, both of.
Huh?
Well,
Okay, fine. Let us not do this exercise. All dispose of. Anyway, we had some knowledge on this.
the legislature has done also.
We'll not record all those things. We'll dispose it of all. Huh?
Okay.
In terms of this order, individual order of a particular.
I need to indicate the section.
Part 20. So a contention has been raised as regard the the ratio laid down by the division bench in
Criminal petition 284 of 2020.
2022 as regard applicability of section 460,
451 and 457
451 and 457
at the time of
at the
investigation.
time of investigation, and deliberations were made by the party. However, in view of the in view
Enactment of
the
new enactment of
enactment of
Bharatiya Nagarik Sureksha Samhita 2020.
very no English name.
No, lawyers will start giving a name. News here with you. Difficult grammar.
Bharatiya
Nagarik Sureksha Samhita
Bharatiya Nagarik Sureksha Samhita
2023.
and the prescription under section
497
497
and 498.
498 to the effect that
Custody can be
custody
granted
can be granted
the state of
by
India.
the trial court
At the state
during
of-
the investigation of an offense, learned counsel for the parties submits that the matter may be relegated to the learned trial court. The parties may be relegated to the learned trial court.
in terms of type of
Relegated to the learned trial court in terms of a order passed in criminal petition 350 355 2022 2020 considered above submission and prayers allowed. Accordingly, the following order
it seems, my lord, as per my understanding. Earlier, it was consciously not included, but because of the Honorable Supreme Court's order, the investigation has been stopped. Incorporated.
our view was that it was necessary and because
Practically, it was necessary.
necessary for a small thing, if that period of power is not given, it's difficult, very difficult. The person will take a truck.
In fact,
Suppose it's not a serious offense.
If a
There-
vehicle is stolen,
Uh,
the owner is not getting the vehicle
Vehicle.
because investigation.
So laws should always prescribe or interpretation should be in favor of a positive thing.
I
Then
think by
never
that, my lord, what the government wanted.
that
Deeply
is your job.
Deeply applied. Deeply applied.
I know outside of that.
Okay. Then item number 4, the learned counsel for the petitioner submits that as the petitioner has already got the written instruction of written. Accordingly,
Here is there.
Huh?
Is there
We
order-
file criminal case. So they can make an application. Everybody takes
you have got it.
against that, my lord,
I
they
got
prefer a
it.
criminal case. So let them file
Okay,
an
you
application.
file under that put
All are disposed.
all are disposed
Okay.
in terms of
They vacated all this.
okay.
Apply.
I submit the- that's not
Item number 6. I'll go through it.
about. So,
Traffic order ordered that in his case, we'll have a separate order in his case, investigation already over and not an accused case. So we will also go there. We'll go there and finally the order trial court shall consider their application in terms of what
All right.
may I say that?
Yes.
that we have already you give the SOP because we say that whether it's human consumption or not, it will be a different consideration. Division bench judgment.
Yes. There
That
are
will
other
be
use of
different
this.
conditions.
There are
Suppose
other-
somebody sells, then it will be a different offense.
There are other use of that.
If you- Just keep this to that.
No, my lord is not rejecting. My lord is
We have
Relegating-
relegating the entire matter because if we will have to answer their thing, then we'll have to, then we'll say that it
Answer
is,
on
this
the
judgment is binding upon us, division bench judgment. So petition stands allowed.
Alright.
Nobody has argued. On our own, we wanted to know. Now we will not go to that. With the division bench judgment, why should we? It's binding precedent. When occasion arises, if other division bench disagrees, we cannot disagree with a division bench. It's a binding precedent.
Everybody will make an application. The court will decide. Oblige.
All-
I've already received the PDF. Have filed on the
Who file affidavit?
Inspector General raised it. Evidence.
Yes, doctor. What can we do for this man?
Your Lordship, look at the fact. He is working past 40.
The Talukdar will take up this matter from other. Okay. We give a convenient date. We'll do something. There is a judgment of Tripura High Court.
I have like to submit
What you want to submit?
both the big case.
Tripura High Court judgment dealing with all this Kumar Devi and all subsequently what
Lordship.
by my Lord Justice Qureshi.
Affidavit.
Huh?
Affidavit.
I think so. Give the judgment if you have a copy. What is this, Mr. Talukdar? Is that the orders?
Yes,
Judgment of, okay. Okay.
Was raised. That whether the prosecution technically protected that there is no protection of extra rights. The case I have said,
Okay, we'll take up
Look.
this matter next week. Give a date. Talukdar, let us take up this matter on 6th or 7th March. 7th of March. 6th or 7th. We'll decide on it. Now this is the matter. We'll think over it. But whatever we do, it will be a precedent. It should not be like that some judgment we pass and it is that it creates a havoc. That should not. We have to balance. Empathy is something and judgment is something.
My lord, the last case,
Ah.
my lord, there is the order 224.
Cannot.
My lord, my friend Vinod was appearing and he is tied up in court number 1 with lot of matters here. They are correct. Court number 3, that is the problem. But can this sort of taken up here again? You will hold it.
It is submitted at the not started that with this book about the art. Yeah, art of it. Where is allowed this paper? Huh? After 5th of March, debated 14. Yes. Mm.
Serving as a higher electrical backup of but was not the but they in the meantime the police officer started but police for what I have observed here and he he was called for interview and he is polling letter is at real 20 sector A
Real.
sector A real 20 polling letter is number has been put as D 086 he is represented but was
Okay.
maybe number of D. So it examination health health after 5 years.
Mm.
Itself in that cell called the seed of place of this roll number to another person has been noted as roll number 0 So
In serial number,
self no self my self in a yet serial 21 24 in 24
no, page B, page 21 is the select list.
yes, my 21 there are
Ah.
one is selected but needed appointment that are waiting list has been
And next are D,
next C
series
yes
C,
23 there in
serial 36,
serial 26
Pranjit Kumar Tamul,
yes my in serial
36,
36
name is Pranjit Kumar Tamul.
one Pandit Kumar Tamul has been
Yes.
shown as flex. But this Pandit Tamuli,
Hmm.
Kumar Tamuli was taken. In the there is a list of applicants.
Hmm.
Original
Hmm.
origin of applicants is the but in the affidavit they have shown that there was 88 that is
According to them, as per affidavit, what is their stand?
as per affidavit they are shown as applicants in 88 not 46 of environment. Not 40. It's not. Another point is that, my lord, actually, in the affidavit, just the original list of candidates was signed by the Assistant General Manager. I don't know on 21/11/14. Now they are saying that the candidate, the petitioner himself, went to take original statement, original statement of ticket, and out of inadvertently, out of to her side, the assistant general manager have signed. In this, he has manipulated. Secondly, the officer said that his name under 36 was D, but here he has written D. But his interview letter, roll number was shown as D. How can candidate number have come? He was serving earlier for more than 7-8 years from from for about 7 years, my guess as regular Ohio. So now the letter is there. The office has not stated to the city that there was an inquiry committee. Inquiry committee is there and they have the report is there, my lord. In that report, Please, some control. Here, the inquiry, the final citing, that the inquiry committee consisted, right, order number
Where do you get that?
0,
Page.
report.
Affidavit of the
Right.
affidavit of the.
This is not a report.
Where do you get that?
Given file.
What is that report? That report.
Report. In the inquiry report, my lord, it has stated that the inquiry committee consisted, right, order letter 16 in account, sectorial, sectorial, and among the electrical subdivision on 2022 for a field inquiry and verification of necessary documents. On verification of official record produced by the Nagaur Electrical Circuit, a copy of the list of selected candidates for ITA and departmental as per star of appointment of Ohio as per merit. Nagaur Electrical Circuit PL as number 2 rating was found and the state list feature the name of the Sunjit Kumar Tamil number 083. However, original copy of the same, but we have collected the original list of the candidate by an ITA. We have collected it, and it's our side. There is no such name in original certificate. But how this name has come? Then second was the letter number Iman from the then SGM chart of the Nagaur Technical Circuit was produced, from which the following highlighted. In reply to an application, RTI, by Sri Jibam Chandra Barati applicant, my lord, if it is not, he was provided with a photostat of merit list on 14/7/14. Applicant photostat copy of the merit list. On the next day, that on 15/7/24 at 14, Chandra Bara went again and obtained the signature of HM HR, office of the Chief Electrical Officer, Nagaur Electrical Service, on a copy of merit list already provided to him. Then HM HR, office of the CTO, Nagaur Electrical Service, clarified in his letter that state list, which was produced for us, yet missed to notice the insertion of D in the roll number of the Smart Tabuli, all sides and signed by the copy produced by it. How is that by the? This roll number is always found in the card. He was not a candidate for this Ohio, but now the officer is telling that he got what is the letter D when he signed the original paper. So, entire matter deliberated by the officer. And the inquiry committee, who are the inquiry committee? Inquiry committee, respondent number 2, respondent number 3, respondent number 4. They are the members state. They are the related, connected officers in case of this matter. So it is unfortunate that for against a very low pay, less pay, a boxer, like boxer, not boxer, like boxer. Employees against employees, we enter Peter, yes, fast. So, my lord, again in C, then ACM picture, Magoilic to clarify C. Number study, he has to clarify that in the list found in the relevant file number demand, the Ronjit Tamuli Picture, in serial number 36, case roll number 083, that is good part. There is no roll number 083. That is roll number D0. But they are telling that the D comes after the result is out. But this is a signed paper, signed. The list is signed and stamped, original list of candidates. So all these are imaginary, imaginary matter they have set in their inquiry report as well as in the report. So, he
Now,
also mentioned that, mentioned in this letter that original copy of the state list was not present. Original in the file, and only a photocopy, photostat copy of the. Now they are shifting like anything. They have no original list, original file. That respondent number 5, Ronjit Tamuli, was not called for interview. He has no roll number, no calling letter. They cannot show that he has a calling letter. They cannot show that his roll number was not D0 is appropriate. Now from when the number is brought and the innocent go paid has to pay. He now time for it. Retirement is coming now, my lord. He is now at the stage of retirement. After 5 years, he will be retired. Still he is serving. But lump sum amount is given. Sometimes continuous, sometimes plus. A very innocent person has been bribed. Again, my lord, if the inquiry committee, regarding inquiry committee, I have objection. If they have could not see the original file, the application, the list of applicants, calling letters of both the parties, petitioner and the respondent family, all declared they could not see. But they are telling that his number was not that. Some Ronjit Tamuli's name in select list was against their party. So, my lord, for the first time I have committed this submission. If necessary, after telling my friends, I shall keep my friend.
yes,
The checklist that the petitioner relies upon was published the year 2000. Subsequent thereto, but the private respondent been appointed on 10/2000. It's been appointed yet the point of cutting of the petition had already been appointed for yet served for 4. Thereafter, there was an interim direction saying that his actual employment is subject to the appointment of the private response subject to the up. He has been thereafter promoted to lineman. Now he wakes up after 4 years, says that he has not been given for the selection and there is something wrong. Like this, he says, now how he overcomes that delay part, he says that the list was published 5 years after the interview was done. It's an absolute. The interviews were conducted, appointment letters were issued in 2011. He did not care to do anything about it. He comes in 2015, says this has only come out in 2000. That is why I am having that. And the appointment letter issued to the private response has not been challenged. My lord looked at the prayer that his appointment has not. There is no explanation as to why a delay of 4 years has occurred in filing this request. Without a challenge to the appointment order method, it may perhaps stop from even raising an objection without the appointment of the private.
Becca, still they have done an inquiry. Not one step at a time. They have done an inquiry. You are also relying on the inquiry. Now the inquiry now is not under check. They have raised a dispute regarding your alleged misconduct or weakness or not. How do we decide all this?
My lord,
How do we decide this disputed question?
my lord, entire court guarantee good stability.
No, that's it. Ella, there is an inquiry report. I think wrongly they have conducted an inquiry report. And there is a finding of the inquiry report that you have manipulated. We are not saying this is correct. There is an inquiry report. They said we have verified record. This is this. You was not even there. It was 083. 083 is the roll number of the respondent number 5. You have put initially you got an selected to RTI and thereafter you put D and got a signature of the manager as P30. They denied that this is not the actual case. He is not there in the select list and that inquiry report I falls on you. Now we'll have to come to a conclusion that that inquiry report is bad. Number one. Or even if that inquiry is not there, they have taken a specific stand in their affidavit. Now, how do you decide this disputed case in a retro?
I thought must be true. Although that no substance to this. It is there document by seal. By seal. This is the select report that is taken by is given under RTI Act. And it is better also not the notice. The petitioner did not get any copy of the result. And he called it under by RTI. And that on the as reply to the RTI, they have submitted.
Number. How could there be any question of manipulation by the petitioner?
We do not
But-
know.
My lord,
That is their finding. Now
finding-
we'll have to come to conclusion that your inquiry is wrong. And therefore, you are the selected candidate. Respondent number 4 is not. Can we do this in absence of any challenge to the inquiry report?
my inquiry report has come now. Not before people pass, up in front of people. They have made inquiry after the petitioner submitted. When they
And
got
what
the
is
notice
page,
from the
what,
court, they
what
went
is
to
page
extend that.
59?
My lord,
What is page
59 is
59?
the liability act.
RT, but
What it says? They say that there is a mistake in Tipon Chandra Bora. Actually, actual roll number is 083 ITI. Actual roll number is D083 department.
my lord, they
In the
cannot
select
just-
list, instead of printing roll number 083 ITI besides name of the Ranjit Tamuli, roll number D083 was wrongly inserted as serial number 36. So they have made it verification.
No, my lord. They have
This is your RTI reply.
their clarification on the their document. See, their documents, not my document, my document.
So they said it was a
So,
mistake. Even if
number
you do not go to the all disputed, they say that there was a printing mistake. in that.
Another point is that he was not a candidate for trial. Please keep the original list. I am finally
How does he have the original
80,
list?
80, 80.
And Malad, when the department is saying that the original list is not with them, how does he have the original?
Yes, I have taken
Malad,
it.
may
I
kindly
have
put a
taken it
pointed
from
query.
by RT, on
Well,
RT.
Malad,
Everything I have
given them a
put it on
certified
RT.
copy. How does he have an original list, Malad? So he must have procured it illegally or it is tampered. Please,
No, my lord.
kindly, Malad, put a
Everything,
pointed
every
query.
number I can tempered. I have tempered the original list also, where his name is not there. He is not applicant for trial, he is applicant for requirement. These are those please kindly see, my lord. 88 against 80, what 88? Against 88, who was applicant? I have seen my
So let it
against
bring it on
88,
to affidavit.
hold on please. Against 88, serial in the applicant's list, one Pranjal Bora, son of Otul Bora, village Honor Post Office, Rupani Kastar, district, yes. Another name is against it. Not the name of Mr. Respondent number 5. And the petitioner serial 109, 109, Dipan Sundar Bora, Dipan Sundar Bora, Department against it. Then, where from this name come, my lord? And his ability, they have returned. Yes, it is a first. There is no choice. But how could this become against the against the post of trial? Who is manipulating? Manipulation cannot be done by petitioner. And employee, great for employee. Manipulation is done by the authority itself. They have manipulated against the low paid innocent person. Injustice on the part of the officer. They have manipulated. Now it is your lordship, but I submit that the innocent voice cannot be deprived like activity of manipulation not prohibited by Peter. Yes.
What is the statement that select list was published long back?
Different flex.
I'm asking.
This is silent stamp by you. So,
Okay. What that what we don't that with the checklist is published appointment
Take more dark. Not to
act at the checklist. You know, whole number zero eight appear. That is the with no T number adequate but highlighted for the term maintained by the department while conducting the interview. The name of the content of the package. Number three. So black. It's the order of appointment. It's in the year. The name of the content number five.
According to you, flag B, flag 2 is the select list. No, no. Flag 1 is the select list. Plus 1 is the select list, and it was
Because the entire section was divided in ITI candidate. The private is not treated as an ITI candidate. It was not a departmental candidate, hence no D in front of it. Now the select list that is questioned is challenging he applied with
the D.
under D. That is the select list for the ITI candidate. Now I have a document. The specific letter of appointment. He's been appointed as a Sahayak Samguri Secretary.
Okay.
you know what? He repeat, they have repeated. They repeat. Get correct. No, they have not with it is because
Mhm.
in part it is that there was eight but really another CDP
submitted by, it is very good, Ahmed.
Hmm.
Deputy General Manager, law, of official, against self it's zero.
What is that?
No,
It is the list of their, list of applicant, my
let me just clarify that.
list of applicant.
Where is
Let me
that?
just
Affidavit?
clarify that.
There is a zero, my lord.
Where is which page?
It is submitted, it is affidavit, my lord, it is affidavit.
What is the page of the affidavit?
29 of that. 20
Affidavit
of our affidavit.
submitted by
That
Deputy
blank.
General Manager.
Blank. It is because of the photocopy, and the type copy is at page 16. This is a reproduction of the attendance register that I put my thoughts. It's flag number 2.
Page 16.
My lord, anyway, they have
This
not
eight-
been able to show that his
this-
name was in the applicant.
This serial number 88, my lord, is not the roll number. It
They
is
have
the
submitted this, my lord. It is submitted by the respondent, the Deputy General Manager. Yes, my lord, because it is a zero, make it no name.
I can see a 88. So that 88 is a serial number, my lord, it is not the roll.
I
Serial
will
number
call
in
it
the
a-
attendance.
I will call it to copy of the respondents may kindly be asked directed to either the roll number of the number 5, the polling letter of the student for that because parents say company of say they are very present you the record because this is why they have not taken. So other statement should be document to the alien the disease. They are going to them a great example. So the lordship may be please kindly call for their side, their record. Further, they will be given.
Sir, Chaudhary, why your record is all Xerox?
It's the problem. But otherwise, they were certified, madam, taken a categorical stand. The appointment letters are there that we have placed. And the register also is there.
To record can be, but what I have submitted is cost.
Sir, Decca, that you are showing, what was that? Original of something you are.
The inquiry report there is so that
No. What have you got through RTI? You said that these are my RTI.
not at the time of I did there by chair, but they have told that it is not. But they have taken it. But it
What have you taken under RTI? What?
might be I can get this report.
It's just a Xerox.
Therefore, signed by it. Sign and seal. A photo
They
should be
say
read,
that these
my
were
lord.
subsequently, this signature was taken.
My lord, no, it is RT. They have
They say that we have given you
every paper, every paper after when it is given on RTI, sign and seal. But maybe cannot be origin and photo set or type copy type at it in that
Okay. Anything to be added? Take one.
Yes. Calling letters. I'll just flag it.
Okay.
My lord, pulling the height.
Huh?
Pulling the relevant height. That
I have seen their record. They are saying this is what we have. This is what they say they are having.
The doctor day. Then day.
It's 27.
The first thing, 1006 code SCP 32. Para 67.
And
1988 one SCP 31. Para 16.
what is the further hearing? Dictate connected. Today we are shortage of wave secretary. Okay. Today may not be possible.
Meaning the
Give a date next week. Give the citations to Mr. Deka. It will go through it quickly. Next week, next. Huh? 12 months.
Yep.
We have already consulted each other that we make both thought submission and say proceed permitted for file our written argument.
What is this?
The subject matter is very narrow. What 2009? The petition was brought in the now the petitioner has to put the record. In addition, they are also on emergency. On now, what happened on the particular date on 28th 2009? A patient came there out of the requirement. Now, that what bad. Because of that, therefore, the admitted purpose now they did other person not out attended the but the management is satisfied the meeting. Afterward, they indicated the department. So the so-called it was temporary based on the ground that the of just from order to and with first charge rate, how much charge rate both parties that finally have taken that the FD engage the job. But the best was but to the best of the effort. I guess it's not rotated by it's it's
What is the finding of this tribunal?
not finding that the whatever pursuit and whatever that is efficient that is enough. But what's the good that is that,
What is that?
that will put that is the crux of the fact. My lord, disobedience and other thing, my lord, subordinate, etc. Sometimes possible to apply. Therefore, the element of people must be present. That there's nowhere but charge was not. That way, not can this article of the subject after there, but the test supposed to the basic number one. That on 8 when ambulance driver promotes the when it what the right the top you request to attend the good right on board it the bit of your negligence your work is your work number not only decline to attend the duty to fit the intimation to the doctor of the head of the very direct your attack of the this the best of the
What is your reply?
hello track and best 7. That is very important. But second the paragraph start from third paragraph. That's the start. The inquiry page 47. Put the inquiry put up page 48 page 40. It is paragraph first paragraph. And the first this people for a did not end.
Good.
Agar page 48
48.
7th line. This keyboard for first paragraph.
First paragraph.
This keyboard for a did not attend it but for of suffered it was being verbally informed by the director of but in charge they said that no information provided to the higher officer. But not provided
You yourself says in your super class.
the first
You yourself says that no, I did not feel it necessary to inform my higher authority.
that's the that second but those subject the
No, that
there is
understand.
no
That we
that
understand.
there is what question is not what bigger the charge published it's like therefore state where they have come to the page 9 last paragraph that how very it is a single step page 4 last paragraph in this connection it can well established that by verbal of the driver of the ambulance of being accepted to headache cannot accept it both that when they leave to the hospital the for part of the case could accept kept taken out of the on the basis of this only the charge of a bit job but it's not to say but video now come to the second charge regarding charge number
Yes.
all what is here it is stated
Page.
page 40 second part the first paragraph in by saying that I could have given the treatment. Based on that, my lord, it came to the conclusion that the I has been stopped. Whatever. Now, again, the next narration starts from as regards charge. Relative the ex officials left of ability to inform the doctor on 50 his head of the accused official to be said of the driver of the about or doctor of officially either tried or did provide assistance for a good but it edge that process. Therefore, you that record by the time to it, but the next 28 the subject for the it will make generally considered part of the medical concept the lack of the next part work and you can also check the effect to the bubble the drop for the hospital for it if the other charge level in a but it this other it for a level uh, 8 the 5 at the but 5 put it 5 5 8 for a Harvard it the 5 5 5 just a minute.
Yes.
It is but however did not fit the expert method better to the output that the hard and close it with the but the depth method of to get that the method for get the get another one. Now the that they have now it the another one. It last it last paragraph therefore taking into consideration reported the inquiry that was by officials and that of both them and of both them that of for a level yes that next time but now look at from us us might might that go that over the evidence I have read the book I have read that on the basis of this method is one-sided every of now look if that is the second they are three elements but if kindly think 14 is a covered one
What is it?
my lord my lord education is a part of the just control number A the aim willful insubordination or disobedience whether alone or in force willful word is not a single instance my lord is particular with every particular or every now look I am coming to next part I habitual negligence or neglect of work habitual negligence or neglect of work there is no any established that is education proof now coming to my last part okay frequent repetition of any act of a fine may be imposed to a maximum of 2% of the bill. They will not act. They, now what they say about only position of factor. Therefore, they I explain they wrote here. Suppose it will take the amount. Then 2% I wrote the wages taken for the part. Now let us state we wrote page 53, the inquiry report. There are three allegations which they asked. Now, if we look into my lord final part, property part of this of the inquiry report, my lord, there is not a single whisper that which charge that group are on what basis, which part that with what efficiency with last time. Now, lord, if inquiry report conducted or findings are there, my lord, one-sided, then they, my lord, finding report, my lord, suspect the eyes of my application, basically my defense note. Only they committed case misconduct. Now, misconduct, my lord, contains three parts. One, two, three. The three names speak in different language. First is about subordination, is followed by willful. If willful is not there, my lord, that subordination cannot play in bigger. Wherever, but and secondly, habitual action. Okay, no doubt they can take it to consideration, but what what evidence they have, what thing has been considered, what defense they have taken. Okay. And J, my lord, so far this matter frequent repetition. Also, my lord, for what with out of the sub, 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 composite, my lord, this kind of conclusion, my lord, does not say that the thing has been done in the right time. Otherwise, also, my lord, the inquiry officer, I have a question. My lord, the one person cannot judge from book. Now, Lord, to support my case, my lord, the judgment I would like to them. Lord, the is the element of willful very important. That's the 2012 yes.
Just a minute,
78.
just a minute. What are the important findings of the award, in the award?
Award is 59. What next? About silent. I would like to say some. I would like to page 3, the citing 2012. Paragraph 3, page paragraph.
That first judgment,
Yes.
2000.
Yes, but that judgment can't or
Paragraph.
paragraph 18. One page. My lord, it says absence from duty without any application of prior permission may amount to unauthorized, but it does not always mean there may be different eventually which an employee may absent from something circumstances. But in case the employee cannot depend on behavior, department of course it the and the proof that they are skillful that such and not among paragraph 2. The present case the inquiry of the family so here that the applicant was the applicant but it of the state appreciate that there but that there is happen. So it now next citation I don't that 2014 with 574 and relevant part paragraph start from 20, page
Paragraph.
page 11 paragraph 2. We have quoted in excess to page 11 paragraph. We have quoted in excess to as are that the court has wide chart of effect of excess above that are that 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 apart affect the state case management as a and that quite apart that 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 it is obligated of the part from the that is on the opposite understanding of the care of the opinion that the fact it is the fact regarding the good point the nature of charge level against the employee that comes on record saying that as absolute for that whenever there is a wrong answer of the part
which unauthorized applicant does not back you can offer satisfactory explanation whether occupied take report check but the last proceed may that like right without so the experiment built up the nature of the project of project that but here in this case method no such test is taken method next time method that also one of area can that what I the written part of the test not very hard page 8 paragraph 30 in which the SQ of the legal established that disciplinary authority can prohibit the effect of fact find that or consider they are the treatment for the purpose of the High Court but or other benefit punishment for the of the conscience of the High Court appropriately not the release either direct itself an excess there the only routine proposed doctrine is not from best the judgment should get cause 9 with and relevant paragraph should at page 27 start from paragraph 25 what is the doctrine of proposition these are the method that the relevant part of the attack page 29 paragraph 6 page 9 the doctrine of proportionality does well scope and concept of or what is otherwise the domain and for our method 1 by 1 charge or extend a method out the word of one goes and repeated so this be applied by which one could be any reasonable employer that suppose us punishment like better take but major magnitude and degree of conduct and also other better case like the where the the but opposite charge of us can no detect for at but like but good respect respect no but therefore the case that the that there a single instance of the case article the if the to the that offered the page 34 the paragraph starts with page 30 with first paragraph middle part line it was also felt that the servant can be dismissed if habitual negligence or but that for single insolence of servant as a My case, judgment sometime. Or if another judgment if there about it that but it not based but because of but about the breakup start at the page part eight part contain page 49 breakup
Paragraph.
page breakup on last repeated
Paragraph.
breakup 14
One
Page-
four.
yeah one
Page 43.
49
That apart.
yeah the page 49 breakup
Is judgment of 10 court. One. 10
Hello.
court. Start the page 38. 30. You have now numbered now. At page 39 it starts 10 core versus something like
but pride but on the
before the third of the 31.
third person theory afterward next one
We have gone to the chairman of military Coal India. Okay.
Yes.
Page 10, paragraph 26. Then hereafter judgment starts with third of the 31.
quite right
Huh?
that is single I have already referred
That you have referred.
next
That,
one
that page 35 you have referred. Then next is 2 and 4.
otherwise but 1997
Just a minute. Then Monistika Bura,
Yes.
page 45.
Yes. breakup relevant part breakup the line start from inquiry the inquiry officer must act
Page paragraph 14.
for one
4 on January 19. Monistika Bura versus Mr. 39.
But- the relevant part
Yeah. No, there are mistakes.
accept
in that. 13, 14. It started on January 19.
the last right inquiry officer
These
must
are mixed up.
But-
That no, it is a 356, some other judgment. These are mixed up. You have to correct. That is a page 56, but this is the next some other judgment.
may refer the 1997 Kerala about
Start with paragraph 28 of some judgment, then start 8 of some.
may read
That I have read, paragraph 14,
inquiry
and paragraph 15 and 18.
breakup it indicate the yardstick that right by the finding of the appointment that whatever my lord, we will not go to much technically. The I A the principle of that 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 are but if but analyze it no doubt that's the whole fact about it, but the separate part is that it that of it analyze the part therefore the limit otherwise required tested that number two my lord the punishment otherwise that was and so for my yes they itself says that person punishment can whether that can be but second but at best that
Basically, it is not willful
that's the center point.
and disproportionate.
That is the two point. Third point, my lord, equality of the present of person. I have been affected, and that objection I have raised has been rejected. Against the part of the despite of that, he has conducted.
Where have you raised this
My lord, if I written statement, that is a part of record.
written statement before the
But
tribunal,
my lord, it may that I have raised
before the inquiry?
that is their part of record. And fourth state, my lord, my defense no bad tactic. Last one, the body of witness ought to have been conducted the inquiry in manner that I have he exceeded its limit.
That you have said, inquiry and presenting officer has said.
That but otherwise also the yard with I have given my judgment. That says that he can appreciate the whole and that if this operating. He had made a comment, he is liable to be punished. Cannot make that. That ultimately create a situation in advance. Suppose he made a comment of punishment, suppose for a moment. Then the authority ultimately may be influenced by the findings that is given by the inquiry. If they have presented the case that out of that what yet what it but added another line that I would punish. So definitely while the authority taking note of that fact, they would not be they will be charged. But that's conducted the inquiry in a manner it would be the
If first if for judicial report of the data process the inquiry for the correct. So that I understand committed that faithful first faithful what is up to page 15.
15,
Never on
page 15 of this petition.
up to page 16 article of fact. There are three charges were taken. That on 28 2009 when driver keeping of the road to the residence at 11 a.m. with whole book sent to you by its name of for some sent investigation of a defense immediately scheduled you to attend the whole night whole leave from 28 2009 which speaks your negligence to your part of it is to note that this because was that he was that a serious question was in it all you are supposed to now two not only did you decide to attend the you also failed to give information to the doctor or your head of department hospital administration teacher which clearly reflects that your utter lack of negligence and your disrespect to a novel profession that to an executor market the philosophy of demand the based on market of the fixed patient into the sector for sector but then it is also brought to your notice that it what previous or similar listed and the copy of which are closed with the exhibit confirm it repeat against structure and security. First chart was that the evidence of it at the policy aspect. Second, the previous conduct of it. All these dates a list to have been kept committed by you once from misconduct. That's pending order CA2 or LJ. Therefore, Secretary of the General Hospital, Medical also wants you to explain and proceed and make up case having plan. Okay. So my land management is based on parts of work for parts of plan. With that, whether the inquiry officer is the second contribution of the witness. With reference to your above reading from page 17, with reference to above, the outlet I have not to tender my sincere, unconditional, qualified approval or an mission or commission which depend on my part. Throughout my service career, I have considered my service with due diligence and care to my knowledge. It is I have never been to disobey direction or directions passed by my superior. That the reply to explanation call is dated in 2009. That I prefer to state here and now. That's in reference to the article chart number 1 pertain to refuse to enroll 56 whole duty 48 2009. I denied the allegation. We beg to state that on that day I was physically not well, was suffering from acute headache, and because it arises from my preceding disease. Furthermore, being present the disease report, I have appraised the fact to the driver Sri Pramod Dasso. It expressed intimate the same to Sri Sati Chakravarti CMO KNR to force an alternate Dr. Theory who was available on that day. It is evident from the communication Sri Chakravarti on RF by data 33,000 that he intimated about my fit physical position to the next higher authority and arranged Dr. D. Devi maintained the recording. Therefore, it is not correct that I left the situation importantly for sake of negligence, rather because the dispensable health reason I could not be able to attend the court. It is pertinent to state that during that period I was suspected all the indicative since 3rd March to 29th March. There was no failure or laches on my part to perform my duty. Instead, it except the day 28/6/2009 I was not well and stated that no, it is not true that I intentionally or negligently avoid my goal, but presently whatever occurred, it has certain thousand reasons which I have referred herein above. Taking into account this certification, the allegation given part 1 may be exonerated. This is that the reference to para 2, the article of chart regarding not estimating the to doctor denied the allegation to most successfully beg to state that there was no intention not to estimate about my not attention to doctor, but because of my health condition, I was not positioned to move, but their personality. As I got the driver mode Dr. nearest and so for him he conveyed the message to the Dr. about eligibility to the board. As such, as much as the conduct of Dr. CTV for the same, the latter part, so someone came to know I came to know that the basis of message conveyed Chakravarti under the situation and arrange the alternate for the state patient positively is what can expect that as a situation where managed was sufficient to by me. Therefore, I further not feel it necessary to contact the higher authority for the same without reducing which might the part of my best that thereon. Therefore, could be stated that I typically failed but so someone that condition was unpaid and this could make evidence from the letter dated 2009 message by this paperwork such as here and need could as pointed out in the state proposed notice. Further, without prejudice, I humbly stated that the negligence or misconduct in this beginning attributed to me was the reason stated in above to be I again complete entertainment and the question. On the paper, static was it black. Lordship, the operated not it is that very was black. Lordship, it is not the case of the technical that he was not he appeared to the witnesses their profession. Lordship is not to respect of the expiry officer. The thing was raised for him during the body. Although was raised for the trial. That has been addressed by the legislature. Now, my learned friend stated that expiry officer has not considered okay, this is not question comes to page 47 that 4% deposit. Page 47, except 5. Merit. Entry to the memorandum pursuant to by the 60 January Hospital Hospital. Pointing under the inquiry officer to draw that against the offense or a debate technician. As per the Department of Hospital. According he was suspected at conference of the Chief Hospital of 2/6/1997. The following proposed were by the Secretary. 1. Copy of memorandum to University Bora, Debate Technician, Hospital Hearing Officer, questions to be discussed of conflict of the offense about charge levied against 62 and 2. Copies of documents MD Office to take the University Bora as Secretary Hospital sustain charge levied against him. Security list of defense are being told. Copy of the statement of defense made by the University Bora, Deputy Technician. He submitted document that was considered by on the day and place, time of work, that is on 2/6/2008, conference of April 11 a.m. The charges is followed by a data paid over to the Bora, Deputy Technician, all hospital at 11 a.m. The whole book of some serious cases of for these three not of prohibited labor was sent accidents of the University Bora with expense to pick up him and finish the hospital. But state Bora is present the whole particular day that is the date for the 9th. University Bora is not attended emergency for the three having suffered from headache was being verbally informed by him the driver of 2. Not only the Bora declined to attend that, but the official information to the doctor or to the head of department or hospital administration. 3. State University Bora.
Well, are you in the record?
But the record is called for that of the tribunal. Regarding notice, sorry,
I think that inquiry technically he thought is that inquiry
copy that is acceptable. It's only with regard to tribunal. So, Lordship tribunal also took the evidence of the both the different as well as the Lordship it says that special review of what has to see the
that yes, because facts and
determination whether it was there is any flow.
law, procedural law, and until and unless perfect.
Yes, that is
That is only in case of perversity.
Lordship that all tribal about but for Lordship. After definite finding that there was procedure was followed meticulously, all opportunity of personal and principle of place of this was followed. Well,
Now, basically, asking willful. Again, willful, you have to go to the willful. Now, then you'll have to look into the perverted.
Yes.
Now, the third thing itself, when statement of allegations are given,
So what is
it is specifically stated, so therefore a misconduct under PIN and PIN A and something like
Yes, yes.
that itself under the definition comes.
no, but if have to appreciate that without the word
Ah.
food, whether materials are available on the record. Whether
So
it
that's because the judgment he has relied on itself says that it is not necessary that the word willful is to be
Yes.
used every time.
hello, yes,
His judgment he relied on.
the judgment says that, but if has to see the material, what is the material, whether he has given an opportunity of hearing or
Now, what made another argument regarding non-appointing of presenting
yes, but if there is a judgment of Supreme Court,
that part you just
but if in that case, but if he has to say that
prejudice.
the prejudice has been posted of the material, and this plea was not taken before the you. It was also was taken before the tribe. That was addressed by the tribe.
Right. I have read that.
That has been also addressed. So this is the law. The has made argument that but it is not considered his argument is evidence as in the material. That is absolutely incorrect. It is so that each and every opportunity was given to him was given opportunity to cross-examine the witnesses of and this is the Rockford Matrix to see page 48. Paragraph it is given to the Bora, page 48.
Page 48.
It is given to the Bora, accused official, however, did not plead guilty to the charges made against him. Copy of memorandum presented to the particular charges which were read over which said to the Bora. The statement made by him response to the charges made against him as enclosed exhibit 2 and 4. Saying Sri Jivantoti Bora accused official was cross-examined. Verbatim quote is based on questions and answers put to him reveal the following in exhibit 4A, 4B, 4C, 4D, 4C. Sri Jivantoti Bora accused officials was called you and it
Somewhere these statements are inadequate.
is there. The description.
Huh?
Yes,
No, not double. That how cross examination was done. Everything have annexed, isn't it?
Yes.
Where are those?
so it's the page 21. Page 21. Page 21 is C. The charge were read over to Jivantoti Bora Level 6. On that day, it, it was not paid. I was sick. I not the driver of the what take what him both with the most of the both for now is every patent. I was not I was on leave for marriage for few days. I had leave to take. I had come medically head head of department leave. Not for get it home. I could get it near me. University Bora it could the start project. Are you supposed to attend active for each step yes, all duty registered in the first message with an end to do you like to start all the yes. Your reply to the supposed stated that how do you for the third part so it appears that solve it. Only one day, they don't fix the time. Did you, do you have all the registered and to doctor or the other staff all outside that I can yes. Have you submitted in what are the terms? Yes. Just that in what are the steps that post examination? Okay, to given to the Bora have you have you heard about the Bureau have you heard? Have you got the test of the his main motto have made that goal? Do you have any idea how to expect the implement of the secure process? Have you seen for a yes, for a that is if you know
Okay. It was the
what it
no,
What type?
no. That he has not completed. You
Yeah, yeah.
what if there are only the relying on one judgment that is the statement of India versus David. But the copy is there, but some
no.
there what if this judgment what if I'm relying on the paragraph see paragraph 7
7.
no just if I come to paragraph 7 we have heard the learned counsel for the parties at the outset it is required to be noted that the departmental inquiry began by discipline officer at the discipline authority it was alleged that the court feared that of student is victim of performance by procuring same India state skip come to paragraph 7.2 on the impugned judgment and order passed by the High Court, it appears that the High Court has dealt with the is considered the writ petition of Article 267 here, telling that the management that as if the High Court was exercising the power of the state authority. The court exercise the power the Article has reappreciated the evidence record which otherwise not admissible as said by the court gently as of the Kishore Shah, discussing that the court judicial review and power of the High Court in particular inquiry, concurrent with the finding recorded by the inquiry, is observed held that
So in this judgment, all earlier judgments have
all what is a very good judgment. All judgment has been considered, but by practice by Mulata judgment, PC Chaturvedi case. I'm also relying the one paragraph of PC Chaturvedi. So this is the case. If you plot how the type of election is.
okay, will because we are having a shortage today, so that's why we'll fix a date. Like order and written accordingly. Please better on 12 keep after 19 of order.
What
Okay, we'll see that. That's right. We'll see on that day.
Very first of it, the officer ordered the production of record. That I inquired from the officer is still not there here. This is otherwise affidavit proceedings are complete.
It's a mandano acha. Very
I think it is there here. That's why I wanted to chalo check which time.
may be granted. But at which time to produce the record as directed by the court, the record order dated
Very first order of 1410.
list accordingly on certificate.
Okay. That's the direction of 29 Malad 124. Malad directed to seek a record. I have written letter.
Then in terms of earlier order date
3120.
31 2022
24.
20 22nd. Then so everybody